Welcome to Want to Franchise Your Business? Intro to State and Federal Franchise Laws.
Welcome to Franchising Your Business, Intro to State and Federal Franchise Laws with attorney Tim Pickwell. Tim has had a private law practice representing national and international restaurant, retail distribution, and fitness studio franchise clients with an emphasis on franchise registration, disclosure, and relationship issues. I'm your host, Kevin Rosenquist. Today, we're going to talk about franchise termination, what it is and how it happens in the franchising world. Tim, welcome back. Good to see you.
Thank you, Kevin.
To start, could you explain what franchise termination is and how it typically occurs in the franchising world?
Yeah, it's not typically a good thing. It is similar to a divorce. It is the termination of the contract, the relationship between a franchisor and a franchisee. And sometimes, rarely, it can be amicable. Sometimes there are personal business reasons, a lease expiring, but it can often be messy. And you'd be wise to have an attorney walk you through the process.
What are the most common reasons franchisors might consider terminating a franchise agreement?
Typically failure to pay royalties. Representing franchisors, I love that. It's black and white. Judge, jury, arbitrator, they understand not paying your bills. What are more challenging is terminations that are based on operational standards, dirty restaurant, poor client service, things like that. They can be a little more subjective. And they can be very real, and they can damage a brand. And a franchisor may, want to put the franchisee on notice and get them to clean up their act. But those types of terminations I find to be a little more messy. Example, client ran quite a few restaurants and terminated a franchisee for, among other things, not running clean restaurants, not cleaning up tables, etc. The franchisee who was disputing the termination went into my client's restaurants during lunch hours and just took pictures of tables that weren't cleared right away and all sorts of other dirty spots in my client's restaurant. So again, it could be subjective and challenging to prove those issues. That's why I love the failure to pay options. Very clear cut.
Yeah, very clear cut. Yeah, and I get it. We've all been to a restaurant chain that we feel like is kind of subpar or something like a restaurant chain where it kind of damages how you feel about that particular restaurant, even if you're going to another state or another location or anything.
Yeah. So the franchise agreements we draft can be pretty one-sided in favor of the franchisor and hold the franchisee to a high standard. And to franchisees that complain, we say, hey, look, you're making a significant investment. We're going to hold you to a very high standard to protect the brand and your investment in your franchise. And we're going to hold all the other franchisees to these same standards. So yes, it may seem like some of the standards are challenging or harsh, but if everyone adheres to them, you have a winning concept and consumers have a consistent experience across the brand and from state to state or when they visit at an airport. But if you have lax standards and you don't enforce them, then just as you mentioned, Kevin, the brand declines and you have problems.
Yeah, because a lot of times you don't even know that they're franchised. You just assume it's the brand itself that has the problems.
Yeah.
How does the process of terminating a franchise differ when it's initiated by the franchisor versus when it's requested by the franchisee?
Well, if it's reverse order, if it's requested by a franchisee, usually their best option, if it's a successful unit, is to sell it and get out of the system. And that may be the best solution for everybody. But just wanting to terminate for the heck of it and continue running the business is a non-starter typically. But for a franchisor, it usually starts with notice. There are limited circumstances under which you can terminate a franchisee without notice. Examples might be abandonment of the franchise, conviction of a felony. Saw that happen in San Diego to one concept. And so those you can immediately terminate. But for the most part, it's a notice, and it's called a notice of default. And while your franchise agreement may say, we're going to give you 10 days notice to cure or 30 days, the important thing is clients approach me and they tell me that we're having a problem with this franchisee. We want to send them a notice. And my very first question to them is, what state are they in? Because notwithstanding whatever the franchise agreement says, if it's California, we might have to give them 60 days notice. If it's Indiana, we might have to give them 6 months of notice and an opportunity to cure. Yeah. Same with Connecticut. Other states have no requirement for any particular notice period. So it can be very state specific. And so that's like I said, it's my first question. What state are they in? And then we go from there. And I love documentation. I don't like text so much because they're harder to document. I like emails. I like visits. I like reports. And then, of course, we need to send letters certified or by FedEx or similar to put the franchisee on notice. And frankly, the cure rate that I see is usually pretty bad. So,
Really?
yeah, it could be the franchisee is struggling. They're having problems for some reason. They lost their manager. They don't have a trained staff. That's a huge problem. Franchisor may have to send somebody in at great expense to the franchisee and the franchisor to manage the business. But franchisees who are on top of things rarely have problems, never get notices, and you love them, and they get awards at the annual convention. They're your high performers, yeah. But when they start to struggle, to me, it's very rare that they actually turn it around.
Yeah, it's almost like maybe they just lost the passion for it or something, right? Because obviously they got into it for a reason.
Yeah, biggest reasons I see are divorce, some personal problem, a bankruptcy, which can be a basis for terminating the franchise, but usually is a significant sign of financial trouble. Sometimes the first sign of trouble comes from the landlord when you learn the franchisee is 3 months behind in their rent, and that's usually not fixable. And it's kind of the franchisors in the agreements we write may have the option to take over a location if a franchisee is struggling. But the challenge is that if the franchisee is struggling, it may be because it's a bad location. It may be because they've kind of wrecked the brand in that neighborhood, vicinity, town, whatever, and it's going to be difficult to turn it around. But I do have some clients that they feel the location is very viable. They approve the location. They like it. They think the franchisee was making some mistakes and come to some kind of a termination or mutual agreement for the franchisor to take over, resuscitate the business, and then maybe sell it.
Mm-hmm. What kind of legal protections are there for the franchisees if they're facing termination?
State franchise laws that require notice, require opportunity for the franchisee to cure so that they can turn it around or get training or pay the debts they owe. So yeah, immediate termination is a little bit rare. I'm engaging in one this week, but with some very clear-cut violations. So the franchisee's protections are typically state law. So if a franchisee walked in the door, I'd want to know what state they're in and whether the franchisor gave them adequate notice. I have seen franchisors who try to do things in-house, and they look at their franchise agreement and it says 10 days notice, and they're oblivious to the fact that the franchisee is in a state that requires 60 days notice. And so that default notice is invalid from the get-go. So very important that everybody know what jurisdiction they're in and what their rights are. And then for the franchisee, a further protection is that most agreements provide for non-compete, where the franchisee is not allowed to continue on in the business after they've been terminated. They must remove the signs. They must stop using the franchisor's intellectual property. That said, non-competes can be difficult to enforce.
Yeah.
And very hard and almost impossible in some states like California, which is why we are relying on protection of intellectual property more frequently now instead of the non-compete. The franchisee can continue on in a similar business, but they can't use the franchisor's methods, procedures, intellectual property, software, that kind of thing.
And obviously they're not going to get the back. If take a restaurant, for example, you're not going to get the backing anymore, or the food, the recipes, the branding, all that stuff.
Correct. And I recently saw a chat on the American Bar Association Franchise Law Forum. Someone was looking for a consultant to go into a restaurant owned by a former franchisee because they felt the franchisee had stolen all their recipes and was continuing to use them. And so they wanted to analyze the ingredients and the menu and the recipes. And I found that pretty interesting, but not terribly surprising.
Do you have any idea what happened with that? Or is that just something that you just saw? Yeah. That's interesting. Yeah, for sure. Can you walk us through the typical steps a franchisor must follow to terminate a franchise agreement and stay in compliance with federal laws and maybe in California law?
Yeah, it's pretty basic. You want to give the franchisee ample notice and opportunity. And it's really rare if the first notice to the franchisee is a letter from me, then that's a problem. They should have been counseled. They should have had visits by the operations people. They should have been told where they see problems and where they see some opportunities and how to fix them. And if they continue in default and they have failed to make corrective action, then you get the first letter from me. And it's rarely a termination, but it's a default notice warning them that they need to clean up their act. They need to do this, that, and the other thing, or their franchise will be terminated in 30 days. And, I've written several notices for a particular client, and he found that several of his franchisees were not paying their employment taxes. And in fact, were behind by significant dollar amounts. This is a restaurant chain. And so we put them all on notice, and they got it cleaned up. And some of it was impossible to cure in 30 days. So we put them on some payment plans and some other plans, and they kept to it. So that's the first step. If termination follows, there's either a closing of the unit, or the franchisor may step in and take over the unit. But after that, in the franchise disclosure document, we have to disclose in the next year the name, address, telephone number of every franchisee who's been terminated, quit, or left the system in the prior year. And so I call that the anti-franchise sales list, but you have to put it in. And so you'll go through an FDD, and if a client's large enough, they'll have 200 franchisees and some area developers, and then they have a page of 4 or 5 or 6 people who left the system. And I've represented franchisees who call those people, and sometimes they get valuable information. And one client said, I came away from those conversations thinking there was a reason these people were terminated. And so the list is helpful and it's required, but doesn't necessarily kill franchises. And that at that point is typically the end of everything, unless the franchisee violates a non-compete, uses intellectual property, does something like that.
Are there situations where a franchisor might wrongfully terminate a franchise agreement? And if so, what are the potential consequences?
No, none of my clients would ever do that.
Hypothetically, Tim, hypothetically.
Good advice. But yeah, that is the claim. And if you wrongfully terminate someone and kill off their business, depending on the jurisdiction you're in, you could owe them a lot of money. And I've seen a couple of cases recently, and it's shocking, where an arbitrator awarded 6 and 7 figures to franchisees who alleged they had been wrongfully terminated. And that can kind of get your attention if you're a franchisor. A franchisee who's been wrongfully terminated may be entitled to all their money back that they paid, but their damages, lost future profits, everything. It's so rare, though, because if a franchisee is successful, generally speaking, people are happy in the relationship. Franchisee's making money, franchisor doesn't have any complaints. But yeah, very rare. Does happen where there's a wrongful termination, either not enough notice provision given, a violation of the California Franchise Relations Act. So we try to avoid those.
Yeah, I would imagine. What are the potential consequences and outcomes if a franchisor is dealing with a franchise termination without getting an experienced attorney involved? We talked about this a little bit in the last episode about how complicated this whole thing is. Do people try to go through the termination without getting an attorney involved?
Yeah. So the 6-7 figure arbitration award I just mentioned, that started with the client just deciding to do things on their own and not involving counsel until it was kind of too late. And at that point, the franchisee, somebody referred them to one of the better plaintiffs' franchisee attorneys in the country. And he wrote a letter and then another letter and then filed the arbitration. And I had an opportunity to look at the file. I was brought in late, and I couldn't believe that the executive in charge, now no longer with the company, received letters from plaintiff's counsel and didn't involve a franchise attorney. I was a little dumbfounded by that. So I'd say if the other side has hired an experienced attorney, you'd be very wise to get one yourself, or you could step on a landmine.
Yeah. I mean, when you help someone set up a franchise, it sounds kind of like you're part of that for a long time afterwards, perhaps forever or until you retire.
That is the goal.
Yeah.
And so, we don't just draft the initial FDD and walk away. We try to advise them on registration process going forward, and especially franchise sales going forward. Classic example, I have a client, they have a prospect in New York, but the registration is not matured yet in New York, so they can't accept any money or sign the franchise agreement. But the franchisee is hot to trot and wants to come to training. So we're walking in through all the pitfalls, how to possibly handle it, how to possibly use a non-disclosure agreement. But we hopefully are involved on all the sticky processes along the way. And then, of course, the FDD has to be updated annually, if not more frequently. has to be updated annually. You have to renew your registrations annually. So that's ongoing, continuing legal work, but also like to be consulted when they're having an issue with the franchisee or they want to make changes to their operations manual that are significant. Those types of things, we get involved.
When it comes to best practices, should a franchisor, if they're having problems with a franchise, try to handle it on their own first, or do you think it's important to get counsel from the start and do everything more in a legal way, as far as communication, telling them to clean up their act if necessary, that kind of stuff?
It kind of depends on what the problem is. Is it one or two bad franchisees in a robust system, or has there been some change and half the system is in open rebellion? And has hired counsel and formed an association. So it all depends on the nature of the problem. Just counseling the existing franchisees on how to clean up their operation and run a better restaurant, that's really the franchisor's bailiwick. Don't have much to say. I don't really know much about, how to train a Pilates instructor, that type of thing. But it's failure to perform to the black and white terms of the franchise agreement or the ops manuals. And franchisor is taking it as far as they can. Sometimes the franchisor doesn't really want to escalate it, and I'll ghostwrite the letter and it'll go out under their letterhead and their name. Sometimes they do want to escalate it and it'll go under our name. And hopefully the franchisee takes things a little more seriously when they get formal notice from an attorney. But it all depends on, how the franchisor thinks it might play out and if they want to escalate it or try to get a softer resolution.
Mm-hmm. No, that makes sense. All right. Well, thanks for tuning in to Franchising Your Business, Intro to State and Federal Franchise Laws with attorney Tim Pickwell. To connect with Tim, visit pickwelllaw.com. And don't forget to subscribe to our channel. Leave us a review. We appreciate it very much. Tim, I always appreciate your time. Thanks so much for being here.
Thank you, Kevin. Thank you very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.